big decision already out there this morning, and we are waiting for the Hobby Lobby decision, which will come down, we expect any moment now. But the first one that came through was that public unions cannot make non-members pay fees, and it had to do with a home health care worker, Pamela Harris, who is the name and who brought this suit. She's the woman behind this case, and Mike Tobin is at her home in Winthrop Harbor, Illinois, with her reaction to this morning. Good morning, Mike and Pamela.
Good morning, Martha, and let's go right to Pamela. Pamela, your reaction, it looks like this is what you wanted.
It's exactly what we wanted. Justice Alito has just finished reading his opinion from the bench, and it says right here they hold that they reverse the judgment of the Court of Appeals. This is what we asked for.
So what does that do for you with your ability to provide 24-hour care for your son?
What it does, in essence, is it says that we are not state employees, that the person we work for is the person with the disability. I work for my son, Josh. He's the consumer. I'm not a state employee. I cannot be compelled to unionize. I do not have to pay union dues.
Now, we see the reaction as well as some of the writings that this does not gut public employee unions. Was that ever your goal? Did you ever consider the unions really an opponent?
That was never our objective. Our objective was to remove the threat of unionization in a family home and to preserve the relationship between a mom or a dad caring for their disabled adult child.
Well, there you have the reaction from Pam Harris there, Martha. Essentially, the ruling says that family health care providers or home health care providers are an exception, and no one can rule that this little home near the Illinois-Wisconsin border is somehow a union shop. Martha?
Big day for Pamela Harris. Congratulations to her. Thank you very much, Mike, for bringing us her reaction to this case. We are keeping one ear, of course, to the Supreme Court still because we're waiting for the Hobby Lobby decision to come forward. There have been cheers outside. We don't know, how to read all of what's going on outside of the courthouse right now. We do know, though, that Chief Justice Alito has written both opinions this morning, and we are waiting for Shannon Bream to read through this. But we are getting some early indications on how this is going. So the Hobby Lobby decision that is being made is whether or not employers with religious objections can indeed refuse to pay for certain contraceptive methods. Hobby Lobby is a for-profit company. But they claim, it's a family-based company, they claimed that they could exempt certain forms of contraception from their mandated health care plan under Obamacare because they went against their religious beliefs. So it raised the question, can a corporation, a public corporation, have a conscience? Can it be a religious entity to the extent that it cannot be asked to sidestep its religious beliefs in order to provide contraception for people? And the argument the other way was that they couldn't deny women who worked for them the coverage that is being given under Obamacare by other corporations. So all of this, obviously a hot debate. How narrowly the court ends up viewing this is also one of the big questions here. Will they be identifying the specific contraception drugs that Hobby Lobby was against in this opinion, or will they take a broader view of it and say that corporations do have a right to pick and choose among the aspects of Obamacare that they feel comfortable providing? And all of this, of course, goes back to the notion that prior to Obamacare, companies made a choice as to whether or not they were going to cover people. Now they have been forced to purchase something, and Hobby Lobby said if we will be forced to purchase health care on behalf of our employees, then we also can use our discretion in terms of how we believe our religious beliefs apply to that. So, Eric, we are seeing on the wires some early indicators here, but we are waiting until we have the absolute backing of our own reporters on the ground, and they've read enough of this decision to say which way it has gone. But you can hear some of the cheers.
You hear these repeated cheers by the demonstrators and the supporters. So you can only imagine how this decision may have gone to dealing with companies, whether they can opt out of Obamacare and that mandate. Hobby Lobby actually only objected to potentially 4 of those issues very narrowly, so it isn't the broad issue. But of course, however this comes down, the impact and the effect on Obamacare will be watched across the country, and exactly if that can change the law, will change the law, and how it will affect the executive branch going forward, especially after the decision last week concerning the president and his potential overreach that was decided and some of these mandates that he's done.
So AP reporting that Hobby Lobby has won this case. According to the Associated Press. The justices did a 5-4 decision, so it was a close one. You may remember we had one of the lead attorneys on this case from the Beckett Fund on the other day. She was hopeful that it would be a unanimous decision. That is not the case, and the decision will be read by Justice Alito, who has written both of these decisions this morning. This is the first time that the High Court has ruled that a profit-seeking business can have a religious viewpoint under federal law. Now, you may remember that religious institutions obviously contested this initially, and the administration said, basically, we'll find a loophole for you. We don't expect the Catholic Church, for example, to pay for contraception for their employees, that there would be a way to get around that by pushing it back to the insurance company themselves for the purchase of those. But in this case, they are also saying that that can apply to a private company, in this case, Hobby Lobby and the furniture company in Pennsylvania as well. Let's bring Britt Hume back in with your reaction to this, Britt.
Well, the early word that we're getting on this, Martha, is that this decision applies to closely held corporations. That would mean a company like Hobby Lobby, which is family owned. That would also apply to the other company involved here, which was closely held. Mm-hmm. So that narrows the scope of the decision here. In other words, if General Motors suddenly announced that it, by virtue of some vote of its board, decided that it had a religious objection, that might not apply here. So they've narrowed this down, and it's 5-4. So to some extent, I mean, this is obviously a win for Hobby Lobby, and it's a win for other closely held companies whose owners have strong religious convictions that would apply. But it certainly doesn't apply to all companies, and it certainly doesn't toss out the contraception mandate, broadly speaking. From what we can tell so far, Shannon obviously will have a fuller read on this when she's had a little more time to read it. I'm just giving you a little preview here of what I think we're going to hear. Indeed.
And as you point out, public companies that have shareholders that are also part of the ownership process in those companies would not, it appears, be able to argue this. It's family-owned companies that have a religious perspective in the way that they run their company.
Closely held is the phrase.
Indeed. And people have the opportunity to either work for that company or not work for that company based on what kind of coverage they want to get. Let's go to Judge Andrew Napolitano. Stand by for us, Britt, if you would. What's your reaction to this, Judge?
My reaction is that this is a narrowly tailored and appropriate decision by the Supreme Court respecting the religious rights of the owners of these corporations. As Britt so nicely just pointed out, this is not General Motors. This is a closely held corporation, not necessarily a family, but typically a family. And many closely held corporations are owned by one person, who in the old days would be called a proprietor. So basically the court is saying where you're not a public corporation, where you do not have the public buying and selling your shares of stock, where you have a small group of incorporators and shareholders, all of whom know each other and have the same interest, you don't have to follow this mandate.
Judge, stand by, of course. Let's go to Shannon Bream, who's reporting from the steps of the Supreme Court. Shannon, what can you tell us?
Well, I can tell you it's a 5-4 opinion. It's a win for Hobby Lobby. And as you all have discussed, it does specifically say in the holding that the contraceptive mandate as applied to closely held corporations. That is a distinction here because both of the companies, and there is another one with Hobby Lobby in this case, are family-owned, closely held corporations. So this ruling is for them. But essentially in this opinion, 5-4 opinion by Justice Alito, the split you would expect with Kennedy going with a more conservative wing, says that in holding that the HHS mandate is unlawful, we reject the government's arguments that the owners of companies forfeit all their protections when they decide to organize as corporations rather than as sole proprietorships. And basically it goes on to say that the regulations here violate the religious freedom as under the federal law, the Religious Freedom Restoration Act, which prohibits the federal government from taking any action that substantially burdens the exercise of religion unless it's the least restrictive means. And what I've read of the opinion before, and it is a big one, but so far what we see is basically the reasoning from Justice Alito is that this isn't the least restrictive means. Women have other ways to get this birth control. It's not that they're banned from getting it, but in this case, there's got to be a workaround where Hobby Lobby does not have to underwrite or provide cost-free access to 4 of the 20 contraceptive methods that are covered by the HHS mandate. Those 4, they believe, trigger abortions. They don't see them as birth control pills or something along those lines. They distinguish them. They're talking about morning after pill, IUDs, things they believe that once there's a fertilized egg can end the pregnancy. Justice Kennedy wrote a concurring opinion, meaning He goes with the majority here, but he wrote his own opinion. I'll have to look at that. He's obviously the key swing vote here. And one of the key problems he had during oral arguments was the fact that this law and these requirements came not from an elected body, not from Congress, not from one of the three branches, but from an unelected bureaucracy, the Department of Health and Human Services. He found it very troubling, at least during the oral arguments, his indication was that an unelected bureaucrat could set this policy. At the time, it was Secretary Sebelius. Now we have Secretary Burwell. But basically, it was someone that was not elected or part of the three branches as outlined in the Constitution was handing out something so sweeping. And so you can hear the protesters here, a lot of cheers, some happy faces, some sad faces, depending on where you were on this issue. But basically what it boils down to, for these closely held corporations, the government cannot force them to comply with this mandate. If it does so, it would violate the law that gives them religious freedom protection. It doesn't look like the court actually went the next step to consider the First Amendment analysis, instead finding that under that Religious Freedom Restoration Act, the owners of these companies are protected. The dissent, also very lengthy, authored by Justice Ginsburg, and she starts out with a discussion of women having equal opportunity in the workplace. And I'm guessing, just reading the opening to her dissent, that she's going to see this very much as a gender equality issue. The four justices who normally side together on that side of the bench are together on the dissent today. Guys.
Very, very interesting. Shannon, thank you very much. I want to go to Judge Napolitano and get your thoughts. First of all, Judge, on Anthony Kennedy's understanding of the HHS mandate of this law and the fact that I think it's an interesting point that he makes, that they are not an elected entity and they should not have the right to impose this upon these closely held corporations.
Again, I haven't seen Justice Kennedy's what we call concurring opinion, where he agrees with the result of the majority but has some additional reasons he wants to put in there. But I understand from one of the blogs that of people who have seen the opinion and are kind enough to send it to us, is that Justice Kennedy said, look, if the government, if the Department of HHS was so anxious to have these contraceptive services paid for, why don't they pay for it themselves? He also says there's nothing in the majority opinion which would prevent the government from paying for it. This is not a case, according to Justice Kennedy's concurrence, about the constitutionality of contraception. This is a case about individual conscience. So if the government wants women who are employed by closely held, family-owned, small group of shareholders, corporations, ones that are not publicly traded, and those people don't want to provide it, the government can provide it itself. That's the essence of the Kennedy argument, as I understand it.
Two huge decisions today, Martha and Judge, and in a few moments we'll continue more analysis here in the Fox News channel about one decision that really is a setback to public unions and the right not to pay dues. The other, of course, the Hobby Lobby case, protecting and defending the employers at Hobby Lobby. We will have a reaction from their lawyers as well as from Karl Rove. Two big days at the Supreme Court. You're watching the Fox News channel. More in a moment.